You hear the police were dispatched, and the fire department were dispatched. And at that time, the police didn't know if there was one shooter, two shooters, three shooters. Now they began to try to get around the burning car to assist Anna, who was on the phone with the 911 operator, begging for them to come and help her. You hear how the police would split up. Two women, two would get around the car. And that as while the police were approaching an area near 77, a parking lot down on the ground, which would be below where Mr. Loya was, he began to open fire at them. And that he hit police officer from Bourne, Jared McDonald, in the low.
Welcome back to the Law News Network, everybody. I'm Aaron Keller. I'll be with you for the next 20 minutes or so here as we get ready to wrap the day up. But for some analysis on all the stories we've been talking about, let's bring Ron Bamieh into the conversation. He's with us here frequently on LawNewz, a criminal defense attorney, former prosecutor. Good to see you again.
How are you, Aaron? Nice to see you.
Pretty good. So we're talking about the Adrian Loya case a little bit out of Massachusetts, and I keep saying this over and over again, but just talk about a strange, weird, bizarre circumstance. You've got this guy, he's in the military, he drives up to Cape Cod, goes and attacks another military member that he used to be in service with, and he's got this elaborate stage of this scene staged. He's got fake bombs. He sets a car on fire to block access to the neighborhood. We're looking at a picture of one of these fake bombs on the screen right now. And his only defense here is to try to claim mental disease or defect. Do you buy that at all in a case where you've got premeditation, you've got a manifesto, you've got all these other things?
Well, the facts on their face, speak to crazy. When somebody goes to these attempts and does what most people consider these outrageous acts, we all want to say, well, what's his motive? And, well, he probably had a plan here that spoke to his premeditation, as you just said. The reality is, even to get to that point, to even create these plans, even to think in that regard, there's an argument that, and the only argument you could make as a defense attorney is, like, my guy doesn't know what he's doing. He's living in some world that none of us are living in. And he conjures up these thoughts and these images that led him to do something that most of us could never in our wildest dreams imagine. Because when left with nothing rational to explain his behavior, then we start to think of maybe there's some mental defect or illness that explains the irrational behavior.
Well, it's irrational, but the criminal standard for what we're talking about here is not the same as a psychological standard. So you can be crazy and still realize that what you're doing is wrong. That's the legal standard.
Well, you don't understand the nature and consequences of your actions. But I think what they're trying to say is that, look, he did all this stuff, but he's living in a different world. His mind's not working right. He doesn't understand. I mean, the motives could be anything from he thinks he's a super secret agent till he's just irrational or he's hallucinating. I still haven't heard the exact details of the type of mental illness he was suffering from that would cause someone to do that. But when you look at it from a defense standpoint, otherwise, what do you have? You're going to plead him, guilty to multiple life sentence and possibly a death penalty? That's not going to happen.
Well, we're in Massachusetts here, so, the list of charges that this guy faces is pretty long. I think there's 30 separate counts here, and I'm flipping through to make sure I go through the list properly. He's got murder, armed assault to murder, aggravated assault and battery. There's in a lot of these, there's multiple indictments on the same count here. So armed home invasion, armed assault in a dwelling, use of a firearm and commission of a felony, armed kidnapping with serious bodily injury, burglary and assault on an occupant, arson of a motor vehicle, possession of a hoax device, assault and battery on a police officer. It's like they threw the book at this guy, and I don't usually say that. And I missed one of them. He also has possession of a large capacity feeding device for the weapon he had. He takes a GoPro video of the crime being committed, and they have that. I don't know if I can imagine a more horrific scenario.
Yes, and that's the point I think the defense is trying to make, is that how would anybody even get to the point of conjuring up such horrors? And their point, I'm guessing, is going to be, look, in order to even get there, you have to be insane, where he doesn't even understand what he's doing in terms of why he's doing it or the methods he's using. there's no other defense that they would have in that scenario because it's laid out, it's detailed. He obviously had thought about this for a long period of time. I mean, the fact that you bring your GoPro along for your murder tells you a lot about the guy. Now, does that defense going to work? Is that going to fly with the jury? I'm guessing 99% of most juries, unless there's something significant that comes out during the trial, they're not going to accept that as a defense. Mr. Loya is, he shouldn't be buying any green bananas.
Well, I wonder what's going to happen here because it seems to me like the prosecution's got the upper hand by 5 or 6 hands here or more. But I'm curious to hear what this manifesto has to say. I'm hearing, 200, 300 pages long. And nobody can seem to find any evidence that it's been released publicly yet. So presumably the first time we're going to hear some of the contents of this thing is in the middle of this trial.
Well, let's put it this way. Have you ever heard of anybody who wrote a manifesto who was sane? I mean, just the fact that he wrote one.
Well, I mean, the phrase manifesto is in itself perhaps overly pejorative in the sense that, maybe it's an explanation, not a manifesto.
The way at least it reads, and it seems to the accounts that I've read, it reads like a highly detailed account of what his plans were going to be and some motivation as to why he was doing it. And the way it was described in one account was single-spaced, multiple pages that seemed not to flow and not to have any sentence structure. It would indicate to me that there could be some evidence of mental illness in what he wrote.
What do you make of this claim that the defendant alleges that he was sexually assaulted by the woman who he went on to murder?
I don't know what to make of that. First of all, it's hard for a man to be sexually assaulted. It
is possible.
It's possible, but let's just face facts. It doesn't really happen in everyday society. It's extremely rare. And so he's saying this extremely rare event happened a long time now. What I'm guessing is going to end up happening is the defense is going to say that that was part of the delusion or hallucination that he was under that created this, his impetus to do this.
Well, I'm really curious to see how the defense is going to try this case. The defense has already said that it's planning to, get all this medical evidence on the record. And obviously, I realize when we start with cases, we hear the prosecution side first. And oftentimes at the end of the prosecution's case in chief, we all look and say, guilty, this is it. And then the defense gets up and really starts to poke reasonable doubt into things. And maybe that'll happen in this case, but I guess this case is really going to turn on the legal definition of whether or not he has a mental disease or defect. I guess that's really what's at issue here.
Well, I mean, when you start talking like, we only heard the prosecution side and these types of cases and you can't see where it's going. Well, what you have to understand is sometimes defense attorneys who get cases and take cases, they have a duty to their client. And they got to put the best defense they have, which may not seem like a great defense to your average Joe or even to your average Aaron here on LawNewz. But they got to come up with a defense. And when you don't have a lot of cards to play, you play the only cards you have. So there's no doubt that any rational defense attorney would go into this trial knowing that they're up against it. And there's, just look at the facts of this case. There's not going to be an issue of what happened. It's going to be an issue if you had the capacity, and even that issue is going to be a difficult one to get over.
Yeah, and I had said something similar here earlier. I think this defense attorney seems like he knows what he's doing. He comes across as very sure of himself. He comes across as very bright. He's extremely articulate. I think that he's probably, by what I've seen, a great attorney. But as you said, he's got to play the cards he's dealt. And in this case, I think he's got ones and twos and can't come anywhere close to making a royal flush. But that's the case that we're covering in Massachusetts now. I want to switch gears a little bit and talk about the Valerio case. We just had the prosecutor on, and he said something that really stuck out to me. Apparently, that on first blush, at the first vote back in the jury room, the jury was 10 in favor of the death penalty, with only 2 people looking at life in prison without parole. Eventually, that got flipped around to 12 unanimous jurors voting in favor of life without parole. And apparently at no time did the jury think that this guy deserved parole. We were talking a little bit before we jumped on the air here. Does that surprise you that the jury would go 10 to 12 and then kind of flip almost the exact opposite way to come up with 12 unanimous the other way?
No, actually. A lot of times in the jury trials I've done, jurors will go back and take an initial vote. And the Valerio case is really unique because they're just doing the penalty phase. They're doing it 30 some odd years after he was convicted, when the penalty part of this verdict got overturned by, I think it was Nevada Supreme Court. So it's unique in that regard. So when jurors go back and they say, okay, let's just take an initial vote, let's see where everybody's standing. Sometimes those votes are done without a lot of thought or a lot of consideration for the other juror's point of view. And it doesn't take a lot to move people. In this case, when you have such a long, lengthy period of time where this guy's been in custody, and since the crime occurred, since his conviction, it doesn't seem that shocking to me that if a few days later or a few hours later that people's opinions would change or their votes would change as they consider the facts more seriously. And it also, and every jury, by the way, they're usually decided by 2 or 3 people, sometimes one. The leaders decide. And sometimes when you take the initial vote, those leaders haven't been defined by the group. And then once the leaders are defined, they have a tremendous amount of persuasive ability to sway the majority. So we always like to think that there's 12 people independently thinking in a room. The reality is that 1 or 2 strong people convince everybody else to go one way or the other in most jurors.
Well, and of course, I know attorneys are always trying to get a sense of who those strong-willed people are who might be doing the convincing.
Yeah, when I teach trial practice, I always say, remember, we all think we're trying a case of 12. We're trying a 1 or 2, and you got to find those 1 or 2 because those are the people you need to convince.
Good advice. I had not been taught that by my trial advocacy professor, who I quote sometimes here on LawNewz, but I'll add that back in my brain somewhere. Another interesting thing that we heard from the prosecutor, apparently the jury was really bothered by a phrase in the defendant's allocution. I did not pick up on this. I thought that he came across very well, because some of these things just reek of insincerity. I thought the guy came across pretty well, and so did just about everybody else analyzing it, but apparently the jury didn't think so. The jury thinks that he did a little more harm than good, perhaps, if I'm understanding it from the prosecutor's standpoint. Apparently the jury had a big issue with the phrase of the defendant's saying, "Every day I think about the victim." Apparently they had a problem with that because he didn't say, "Every day I think that I did something wrong to the victim," or "Every day I feel sorry for what I had done." And given that this was alleged to be a crime with weird sexual predilections and perhaps there being sexual anger against women, that phrase, "Every day I think about the victim," without any qualifier, apparently that really bothered the jury. What's your reaction to that?
Well, it's really hard to interpret juries' thought process and what they find and what will persuade them. Now, in this case, obviously, it didn't bother them too much because they ended up voting for life without parole. So it couldn't have had that huge an effect. And they're focusing on, first of all, the crime is horrendous. Let's start with that. The crime is just absolutely horrendous. What he did to that woman is unspeakable. And that alone, when you start even talking about the victim in that scenario, with the thoughts of what the actual crime is, would make it tough for anybody to accept. So them focusing on those words and showing some sympathy for the victim seems pretty natural to me. My guess is that didn't move the needle much eventually because they were more probably focused on why are we killing this guy 31 years later.
Yeah, I mean, apparently that phrase, though, stuck out in the minds of the jurors. So, again, it's always interesting when the attorneys get a chance to talk to the jurors and get a sense of where they stand. I know in some jurisdictions it's really hard for attorneys to talk to the jurors even after they've delivered their verdict and after the proceeding is sort of, off the, off the table, the official part is done. But sometimes it happens. And in some jurisdictions it's allowed. I know of one jurisdiction where attorneys can actually write to jurors after the fact and try to exchange letters with them to see how they voted and if they can explain their reasoning. So jurisdictions tend to be all over the place with this. I know of some jurisdictions where the judge will go in and talk to the jurors after the fact, and everybody kind of lets their hair down, and then the jurors get told all the story behind the story and whatnot, and say, well, we couldn't tell you this, and this is why, but just because you seemed curious, here's what was going on behind the scenes. And apparently the big issue that the jury had in this case was that they kept asking in their questions, why are we here 31 years later? because in Nevada, the jurors can ask questions of witnesses. And apparently one of the questions that the jury kept submitting over and over and over again is, why are we here this length of time later? Why was he already in jail? And of course, you know, as the prosecutor pointed out, and as we all know, that's overly prejudicial. The judge couldn't answer it, but the judge just kept getting hit with the question over and over and over, just couldn't submit it to a witness. So, you know, overall, just a frustrating circumstance with the time, the lack of information that could be legally given to the jury, and for good reason.
And that always hurts the prosecution, by the way, in terms of the jurors with questions and questions that can't be answered. That always hurts the prosecution. And speaking of talking to the jurors after the fact, and you know, I'm in California, I practice predominantly in California, and I always try to speak to them just an introduction the day of the verdict. Say, hi, I'd like to talk to you, but then I like to wait a couple of days, 4 or 5 days later, to talk to them, and hopefully in person. We're allowed to call them if they will, or talk to them or meet with them, if they so agree. Of course, if they say no, we're told in absolute canon of ethics that we have to stay absolutely away, but most of them will talk to you. And I find talking to them after the fact, a few days after the fact, you get a much better feel for what they were thinking. Because the day of, usually you get them justifying whatever decision they made in the case and grasping at things to justify their decision. So I don't find that beneficial, but I find that if you talk to them 2, 3 days later, maybe a week later, you start getting more of the inside story about how they were feeling, who the leaders were, what really persuaded them, and why they made the decision they did.
Yeah, I want to switch gears yet again here, because we've been talking a little bit today about the Eric Campbell trial, because that ended in what was a first-degree murder conviction in and of itself, which was a little bit surprising considering so much of the testimony being thrown at the jury that, you know, the father was the driving force behind this multi-state crime spree, behind the murder of this elderly couple in North Carolina, and the defendant taking the witness stand and ultimately spilling his guts about what a horrible family situation he had grown up in. And a lot of people were wondering if it was going to be enough to sort of mitigate this down beyond first-degree murder. Maybe it would be a lesser included. But he was originally facing another one of these huge lists of charges. And, you know, I was a little bit surprised by the first-degree murder conviction, but I also understand it.
Yeah, well, in this case, you know, first of all, another horrendous, absolutely horrendous crime where these 2 innocent people go into their house, execute them both, basically, and then kill their animals. And there's some evidence that there was some torture involved and things of that nature. So we're talking about a crime that, you know, when your average person comes in from the community to listen to crimes of this nature, it's not like people who are in the profession who hear it. It causes a visceral reaction. And I always find that a lot of defense attorneys underestimate what type of reaction the common person will have to hearing such horrendous facts. Because there is a reaction, and that reaction is that, hey, look, the guy in front of me here is the one I can hold responsible for. Now, my thought was that if the dad was still alive and sitting there next to him, standing trial next to him, that he would stand a much better chance. Because then you could have a villain to actually point to. But the only villain in that courtroom was Eric Campbell, and I could see how a jury would want to exercise some form of severe punishment on a person who was involved in any way in those horrendous acts.
True. The father committed suicide in custody and ultimately left his son to face the rap for it. But I keep going back to some of these facts that the son could have extracted himself from the situation and in essence run away and summoned help in some way instead of just letting the train keep barrel on down towards disaster at the other end of the line.
That type of thought process when you're talking about an abused person is really illogical. A really abused person doesn't think that way. They're under the control of the abuser. And that's the message when you try these types of cases you have to get across to the jury. A truly abused person doesn't have the independence to say, oh, look, he had a phone there. Oh, look, the door was open. He could have left here. He wasn't being watched there. That's not the way an abused mind thinks.
Yeah, but is that the way the law thinks? Because the law just presumes that if there's evidence of a way out, then it presumes that the person should have taken it.
No, not necessarily. The law would look at a person if they believed, and once again, they'd have to believe that Eric was an abused person. Usually, if he had suffered severe abuse, he'd have some form of PTSD, and they would have to hear some psychological testimony saying that somebody in his condition would not be able to react to the circumstances. And they're allowed to use a reasonable personal standard of a person in Eric's situation, a person they believe to have been severely abused, suffer the dynamics of an abused person, and suffer from illnesses like PTSD, and how they would react in such a situation. So not just like how the average person who's unaffected, never been abused, normal would react, but how a person specifically in Eric's situation would react if they buy the fact that that abuse existed and that he suffered from those ailments.
What ultimately should we expect as this case moves into the penalty phase?
Well, my concern if I was on the defense side was that the jury did not seem to accept the evidence of his abuse. And the best thing to save him from being executed would be if they thought that there was some reality, the jury thought that there was some reality, some truth to the abuse defense that they put forward. If I was on the defense side, I'd be thinking, I'm going to have to go heavier. I'm going to have to get better experts. I'm going to have to get somebody else here to testify as to his mental state at the time of the crime and during the crime and after the crime. And to show that this guy truly, while he may be suffering the rest of his life in prison, should not be executed.
Well, I think that one of the reasons why, the jury might not have bought the evidence that the abuse was a mitigating factor in the original crime. They found him guilty, but they might find it a mitigating factor in the punishment. And it's a different standard that we're looking at here.
Much different.
It doesn't erase culpability, apparently, in the mind of this jury, but it might serve as a mitigator when it comes to punishment.
Right, but if you're on the defense side, you're reading tea leaves, like we are right here. And you're wondering what about our defense was not persuasive enough to at least lower the intent that would be required to convict him of first-degree murder. Why couldn't we get a voluntary manslaughter out of this? Now, you're right, the standard is going to be different on the penalty phase, and they could find a mitigating factor that requires life in prison without parole instead of death. But if you're on the defense side and you got a young man's life in your hands, you're thinking, man, maybe I got to do something else here. Maybe I need something else. And, when Mr. Campbell, as I'm sure he will, testify in the penalty phase and, pleads basically for his life, if that's so his intent, you're hoping there's something else to back him up, because you have to think that somehow the jury is not accepting any mental defenses.
So do you think that that there's a strong chance that the defense is not really going to push this abusive family upbringing element here in mitigation, and we might be going towards some other mitigation factors?
No, they're going to have to push it because you can't walk away from it. It's what you have. So they're stuck with that. They're going to go back at it that way, but they're going to think, what else do we have also? And I'll tell you this, I know from studies that you kill animals, you have a higher chance of dying, of getting executed, than if you don't kill the animals. Jurors, for reasons, well, we can go into it, but jurors, when you kill an animal, they treat you much differently than if those animals lived and the same crime was committed. His chances would be